I just muted you.
And do I have the parties present? Do I have Zach Kiyoshi and Alexandria Vaughn?
I'm here, Your Honor. I don't know. I don't think
Okay, that's good.
Alexandria is
I
here.
was like, oh, shit.
Let me just look on my other Zoom screen here. Do we have Alexandria? Okay, so I actually did review this. I had set today for a review date just to check in because we changed visitation. But I do note our subsequent hearing date. Let me just open up the file here. Let's see. The review hearing 11/22/2023. We'll just leave that in place. But I had set today as a review just because we had at the last hearing allowed unsupervised visitation, which was new. So I was wanting a sooner review. But I don't see Ms. Vaughn here. So Ms. Fellows, unless you think there's an immediate emergency issue we need to address, we'll go ahead and just strike today and keep the November 22nd review.
That sounds good, Your Honor. I'm not seeing any issues or hearing of any issues. So striking this matter and just reviewing it on 11/22 sounds great.
Okay. Mr. Kiyoshi, anything you need to address with the court?
Yeah, I was checking on the hearing in November, but I got paperwork saying there would be a hearing today, and I wanted to ask if I could get more time. I didn't know if she was tracking on this hearing or not, but that's what I was going to bring up today.
Okay.
Is that the 2 hours is not enough. It's getting cold, and me staying in Kelso, there's not a whole lot for us to do indoors.
Okay. So what I'll say is because she's not here, it's not something I could rule on. If you want to bring a motion and cite this in before November 22nd, you are welcome to do that.
Yes,
Or
Your Honor.
you could file a motion and we could address it on November 22nd. I
Yes,
would
Your Honor.
recommend maybe reach out to Ms. Fellows if you want to talk about that too, okay?
Okay.
Okay. Ms. Looney, anything right now that the state needs on this case?
No, Your Honor, but I was going to address the court on a separate case once we're done here.
Okay.
Thank
All
you.
Anschutz and Anschutz.
All right, Mr.
We had
Kiyoshi, you
cited
can
on
log out.
today,
Thank you, Ms.
To
Fellows.
address final child support orders. And I did see that Ms. Bigler, formerly Ms. Anschutz, had cited on for final parenting plan, but I did not see that the court facilitator had reviewed the documents. So it looked like we may need to set this over.
I do have this on, well, let me see. Do I have Kenneth, and how do I pronounce the last name? Anschutz? And do I have Melissa Bigler, formerly Anschutz?
I'm here, Your Honor.
Okay. Do we expect the petitioner? I'm not seeing anyone with that name online.
Your Honor, he has messaged this morning. He's having issues. He has no cell service and is having trouble getting Zoom over the Wi-Fi this morning.
Okay. Well, so totally understand that. I did, much like you heard Ms. Looney say, the note I had when I reviewed your paperwork, I'm not saying that it's not all in order, but our court requirement is that it be reviewed by a courthouse facilitator before presenting to me. So you will need to make that appointment here with a courthouse facilitator to go through the final orders first. And then we could set you a new date today, probably. How far out are the courthouse facilitators scheduling? Do you know?
I think it was available next week.
Okay, so you could get in as soon as next week, it sounds like, with a courthouse facilitator. So we could set you out 3 to 4 weeks for a new review date, and then hopefully Mr. Anschutz would be here as well.
And also, Your Honor, all 3 children are currently living with me now. I know on the papers it says Hannah's with Ken, but as of Wednesday last week, all 3 children are with me.
Okay, does that mean that you need to change the paperwork that you've submitted to the court?
Yes.
Okay, so then let's set you out. So if you're going to be changing the paperwork, you might need more than 3 to 4 weeks. How much time do you want? You'll want to get that paperwork done, make the appointment with the courthouse facilitator, and then come back to me. Do you want like 45 days?
Jesus.
Yeah, that seems like it'd be enough time.
Okay, I can get, it's your life, your case. I can give you as much time as you need. You just tell me.
I think 45 days is okay.
Okay, so we'll get you it's always a Wednesday docket, so let me get you as close to that as possible. We could do, so again, if you are not actively having your case called, please mute. Mr. Kiyoshi, I think you are still unmuted. Okay. I could give you December 6th or December 13th. Both are Wednesdays at 9 a.m.
December 6th works great for me.
Okay. Ms. Fellows, will that work for you?
That works for me, Your Honor. Thank you.
Okay. And then Ms. Bigler, you do still have Ms. Fellows on this case. So if you need some support or guidance, please feel free to reach out to her.
I also have one more question, Your Honor. Is it possible to get a temporary order with the kids with me? Because I get state assistance.
You can, you would need to file that request for me to
Okay.
review a temporary order, but you certainly can do that before December 6th. Yes.
Okay.
And if you're not ready to present final orders December 6th, you can present temporaries instead.
Okay, thank you.
Okay.
And the state will prepare new proposed child support orders as the custody has changed. So we will make sure we get those out to the parties as soon as possible.
Okay. Thank you. Thank you, Ms. Looney. And so Ms. Bigler, that was the state who's involved with the child support order. Make sure, and I think you did communicate with them on your final orders, but make sure you stay in touch with them if there are changes to the custody.
Okay, thank you.
Okay.
Yeah, the shock.
Your Honor, I'm not sure. My name is Katie Ostrander. Can you hear me okay?
Yeah. So Ms. Ostrander, I'll come to you next. And then I also saw Dishak. I'll come to you also. Both of you can go ahead and just mute for now. I'll be right back with you. Mr. Jackson, I heard you first, so I'll take your matter. Do I have Annette Jackson present?
Yes, you have, Your Honor. Good
I have
morning.
Annette Jackson, and I have Eliezer Jackson.
Yes, Your Honor.
Yes.
And Mr. Jackson, are you still in the hospital?
I'm back in the hospital. Yes, Your Honor.
You are back in the hospital? Okay. Well, I hope that you're hanging in there. What is your request of the court today?
2 weeks extension.
Okay. Ms. Jackson, I did get your responsive documents to the motion to vacate. I have that matter to be heard on November 1st.
Yeah.
So my proposal anyway, regardless of Mr. Jackson's motion, because today we're just on for a review hearing on the contempt, because the contempt is so tied to whether we vacate the underlying order or not, I think we should consolidate all of these matters and hear it together on November 1.
Okay.
Are you okay with that?
Well, not really, but what are my choices? I mean, he has been having enough time. Every time we had a hearing, he got served. His attorney got served. He was aware of all of those. I had even reached out several times to him and said, hey, does your attorney still works for you?
Yeah.
And none of this stuff has been gotten done. And now my biggest concern, what happened now is I came home last night to my daughter's house because she needed me for babysitting.
Okay.
And I find out that one of my Great Danes had died. He was only 5 years old.
So I just heard a laugh online.
Yeah, that would be his girlfriend, Elisa, Mr. Jackson's girlfriend.
Okay,
And
so I'm just, hold on one second, Miss Jackson. I'm gonna just ask, hold on. I'm gonna ask that everyone remain 100% respectful through these proceedings. Ms. Jackson, go ahead. I apologize for that interruption.
So one of my Great Danes, apparently he just died in his sleep. He's 5 years old. Doctors don't die in his sleep at that age. If he was sick, why was there not taken care of? He has refused me to see my dogs. He has refused to let me get into the house to see my dogs or anything of that. And all of this, so the dog dies. And a few hours later, his girlfriend files for a restraining order against me. Knowing that, you know, I'm concerned. There's 3 more dogs in the house. I'm just like, I really want to get back to my house. I'm like couch surfing since July. They have been purchasing my house. They have been selling items from me. They have been packing stuff up. I had asked where my stuff is. Nothing got done.
Yeah, I understand. And here's going to be my ruling. And Mr. Jackson, I don't need your girlfriend on the camera. She is not a party to this case. No, thank you. Okay. Ms. Jackson, she may have her own case with Ms. Jackson, but that is not in family law court. It's the two of you.
I know.
So I know you know, Ms. Jackson. I am going to consolidate the contempt issues with Mr. Jackson's motion to vacate, have both issues heard on November 1st as already scheduled. Did I get that date right? Okay, thank you.
Yes.
So we'll have you all back. I'm not likely to grant any further continuances, Mr. Jackson. We have given you ample opportunity to be ready. So I am going to move forward. The order that we will do the hearing on November 1st is I will hear Mr. Jackson's motion to vacate and Ms. Jackson's response to the motion to vacate first. You can have brief argument time on that. I will make a ruling. And then depending on my ruling with that, we'll move on to the contempt issues if I keep the underlying order intact. If I don't, then we're essentially starting from ground zero and we would not be having a contempt hearing. So just want to make sure, Mr. Jackson, you know that absent some unforeseen emergencies, we are not going to grant any further continuances beyond November 1st, okay? Okay. All right. Anything else for the parties?
I just have one more question, Your Honor. So when we have this next week, this hearing, does this include that contempt that we had to move from last week to this week over?
Yes, I'm consolidating the contempt into the motion to vacate date because I need to decide the vacate motion before I get to the contempt motion. So we're going to go ahead and put them all together. So yes, the original review that was on for today on contempt will now be next week, November 1st.
Okay.
Okay.
All right.
All right. Thank you both. You're free to log out.
Think you so much, Your Honor. Have a good day.
You too. Mr.
Thank you, Your
Jackie
Honor.
Ostrander, yep, you're welcome. You're free to log out. And do I don't think I'm going to have Lucas Ostrander. I did see a filing from him requesting a change in date.
Your Honor, if I may, I'm sorry. This is Brett Bender. I represent Mr. Ostrander in a related case. And
yeah,
I'm just
sorry, which party do you represent?
Lucas or Ostrander.
Okay.
And he's attending a mandatory union class today. I'm simply appearing to say he has no objection to referring to mediation.
Oh, okay. So he's okay with moving forward with me signing that order today?
Yes, that's fine. I explained to him what it is.
Oh, okay. Thank you for being here. Ms. Ostrander, I know I did see in the file when I prepped this case that he had asked for a new date. So my inclination was simply just to set a new hearing date, understanding his unavailability. But he does have an attorney present today who's indicated he is okay with me signing the order transferring case to mediation. Are you still requesting that I sign that order?
I am, Your Honor. There's a few things that I would like to speak to. First and foremost being that as far as this case goes, I have not been served, nor have I been told that he's being represented by an attorney.
Well,
so that's something I just wanted to bring up.
So, and I'll just, Mr. Bender, I'll respond to this one. So Ms. Ostrander, what Mr. Bender specifically said represents him in a different matter. He's here to make the appearance on Mr. Ostrander's behalf because of his unavailability for today. So if you want me to set a new date rather than sign your motion today, I'm happy to do that. But given Mr. Bender's representation as an officer of the court that Mr. Ostrander is agreeable to this, I am willing to sign it today. It's up to you. Ms.
Yeah, definitely. There's just one other thing that I wanted to mention, and I don't know if maybe I need to file a separate motion for this, but on the 16th, what was that?
Go ahead. I'm listening.
I'm going to stop my video because it appears to be messing with my connection.
Yeah, we don't have any video.
Sorry. On the 16th, Mr. Ostrander filed a document with the court stating that he had reached out to me on Friday, October. Okay, let me turn that back on. There we go.
Okay, we can hear you. Keep going. You're fine.
I apologize. My connection appears to be very poor.
No, we can hear you just fine. Keep going. You don't need to stop. We can hear you.
Okay. Anyways, on the 16th, Mr. Ostrander filed a document with the court stating he reached out to me on Friday, October 13th to request that I change the date, and I did not respond. Okay. At which point I did not respond.
Okay,
because there's a no contact order in place.
okay. Are you making a request of the court today? Okay, we are now having difficulty with your connection. So what I'm going to say, ma'am, is if there is something related to a no contact order, you're certainly free to file any type of motion that you want. I can consider it. I can't consider any of that today. What I've done today is just gone ahead and signed the order transferring this case to mediation. It does require payment of mediation to be split equally between the parties, 50-50, which is common. I will file that with the clerk. Absent anything else from the parties, you're free to log out.
Thank you, Your Honor.
Thank you for being here, Mr. Bender. Thank you, Ms. Ostrander. You're free to log out.
Your Honor, I do request that, can you hear me?
Yes, I can.
Okay, I apologize for my very poor connection. I do request that the respondent pay for the mediation, as I paid for the divorce filing and have paid for every fee so far. So it would be really nice, considering he's also not helping with childcare, if he could pay for the mediation.
So I'm going to keep it at 50-50. That is the motion you filed with the court. It's your paperwork. I have signed it as proposed to the court. Okay. All right. Thank you. You're free. Is it Deshak? Am I pronouncing that correctly? Okay.
It's the shock, Your Honor.
Deshak. Go ahead. I didn't hear you.
Yeah, it's the shock.
Deshak.
Yes, ma'am.
Okay. And then Tiffany Deshak, you are present. Can you hear the court?
Yes.
Okay. So I have us on original, well, when we were here last, we had questions about service of the adequate cause motion. There was also a restraining order request. One of you appears to perhaps be asking for some additional time before proceeding. So I'm not sure who that was going to ask, but go ahead.
Lucas the shock, Your Honor. I was asking for continuance to get adequate counsel and be served properly. I have multiple documents inside of what was left on my porch, and they're handwritten. There's nothing stating from the courts that these are official documents or these are the originals. So
I'm having a little trouble hearing. Can you move closer to a microphone, perhaps?
Is this better, Your Honor?
It is.
Okay. I'm asking for continuance based off of
sorry, you're cutting out again.
Service wasn't done properly. It was left on my porch. There's multiple documents inside of what was left on my porch that are copies of each other and handwritten stuff. There's nothing official from the courts that says this is what was even filed. So I'm asking for a continuance to get adequate counsel.
Okay. Let me ask you this. What day did you get the documents?
It was left on my porch at 10:30 at night on Saturday, this Saturday.
Just this past Saturday?
Yes, ma'am.
Yeah, I don't have an affidavit of service. Ms. Deshak, do you know how it was served?
And my daughter tried to serve him and she filed it yesterday it was her first day off that she could file it with the courts. But we also put in there where she had wrote a declaration on her trying to serve him. I also attached the text messages. I can't communicate with him because the restraining order was already put into effect last month. And so I had messaged his wife because my daughter was, standing outside in the rain for a half an hour and they were home. And I included the text messages showing that he just refused to come to the door and he wouldn't let his wife come to the door to get the paperwork either.
So let me ask you just a couple follow-up questions. So the daughter who served him, is it Adriana?
No, it's Alexandria. She's
okay.
18.
Okay.
Her and her 19-year-old boyfriend went together so that she didn't have to do it alone.
Okay.
And it was all the documents that were filed with the courts. You told me to get a new form stating when the new court date would be, but at the clerks, they said they didn't have anything like that. So they printed out the minutes and then they highlighted on the minutes where you had stated that it was going to be set over to today. But everything else is the original paperwork. It was actually because I didn't have time to go to the Centralia Police Department to get his copies. I gave my original copy.
Okay. So a couple things. First of all, the daughter who served him, is she part of the parenting plan that you're asking to change? Okay.
No.
Okay. So I'll just say from a timing standpoint, serving him on Saturday, even assuming everything else is proper, would not be enough time for him to be ready for this case today. So I am going to allow additional time for him to respond to the adequate cause motion. I will reissue the just a temporary restraining order through the date of our next hearing. So we can readdress the restraining order at that date, but I believe it was put in place ex parte, meaning a judge in this county believed there was enough evidence for it to be in place pending a hearing. Let me just make sure that's true. Yes, on September 26th, a judge in this county did sign that. So I will go ahead and reissue the temporary just through the date of our next hearing. Mr. DeShock, how much time are you requesting to present a response?
2 to 3 weeks would be appropriate, I think.
Okay, so Ms. DeShock, knowing that you will still have the temporary restraining order in place through the date of our next hearing, is 3 weeks acceptable to you?
I feel like that's too long because he's known about even the original court date for a month now, which is why I had to set it out 3 weeks to begin with. And then Centralia just didn't serve him properly. But my main thing is that in Lewis County, there's a no contact order, and Adriana, our daughter, goes to school up there. And so I'm having to drive her to and from school every day, twice a day, until this is settled. And I can't transfer her down to a school down here until I show that I have her. So is there any way we could at least get like a temporary order so I can enroll her in school down here so that she can?
No, I can't do
Or
that.
can he?
He hasn't been
responsible for transportation costs or anything like that?
Nope, I can't do any of that. He has not been properly served. You can't serve him on Saturday and bring him to court Wednesday. So I am gonna move this hearing date to November 15th at 9 a.m. I am signing right now at 9:30 a.m. a reissuance of the temporary restraining order. Sir, this does preclude you from contact with Tiffany and Adriana.
Understood.
You're not to go within 500 feet of the persons. The original order did request an indication that you surrender weapons. I am stating, because there's a restraining order in place, that you're not to own, possess, or control a firearm or other dangerous weapons or a concealed pistol license. However, there's a case called State v. Flannery that precludes me from entering a standalone order to surrender. So I am not doing that. And I'm noting on your order that I've orally told you you're not to possess, control, or own a firearm, dangerous weapon, or concealed pistol license.
Understood.
This order, this time, sir, you were served the ex parte order, but this restraining order does not need to be served on you because you are here and you have been told about it. So I'm taking that off the order. Ms. DeShock, that means that the temporary restraining order in place through November 15 does not need to be served on him. It is effective immediately. I would recommend, sir, because violations of orders like these can lead to their own criminal consequences. I would recommend that you contact the court and get a copy of it, although it does not need to be served on you. I do recommend that you have it with you. Okay. And then did you, sir, just before I let you guys go, did you receive in the paperwork the adequate cause motion that Ms. DeShock has filed?
I'm looking right now.
That's the document that needs the most timely response from you.
Let's see, a restraining order. Can I request another copy of this and being served with the correct paperwork?
I'm sorry, I didn't make out what you said.
Can I request to be served properly with the correct paperwork? Because I feel like I have multiple copies of a lot of different things with what was left on my porch.
Well, I'll let you, if you want to, I don't know what you've received. I will say you've been personally served. You have the documents, appeared in court today. I'm
Okay.
only finding that you weren't given enough time, so I'm not gonna have
That's-
to reserve you if there are documents missing. Certainly
Okay.
something you could bring up to the court with proof. I don't know what's in front of you. Ms.
I,
DeShawn,
that's my point. I don't know either.
well, you know what's in front of you. You know what you've received.
Well, I'm okay.
So,
Multiple copies of the same thing, handwritten stuff. It doesn't make sense.
okay.
They're all stamped by
Hold on,
the,
hold
they're
on.
all stamped by the court and everything. It's my original document, so I don't even have copies of the paperwork anymore.
Okay, hold on to both of you. So Ms. DeShock, you will need to have your 18-year-old file the affidavit so that the court can see what she filed, how she filed it, and when she filed it. Because I do need that. I do need to know what, hold on. I do
Sorry.
need to know what was served on him. Mr. DeShock, you will also receive that affidavit of service. If you believe there is something listed in there that you don't have, feel free to bring a motion to the court.
Thank you.
Okay, Ms. DeShock, did you have a question?
Well, she turned in the proof of service. Is it a different form that she needs to do then? Because it's the court records that they gave us that she was told to use in order
Yeah,
to
so
serve him.
Well, did she file it today or yesterday?
She filed it yesterday.
Yeah, so it takes 4 to 5 days to get scanned into our system. So I think that's the biggest kind of misconception is folks think the minute they turn it into the clerk, it gets into our digital system. That takes several days, which is why we require several weeks of service before someone comes to court so that I actually have it in my system. I don't have it. The clerks probably haven't even processed it at this point.
Okay.
Okay. All right, we'll see you both back November 15th, which is a Wednesday at 9 a.m. Good morning, Ms. Turnbull.
Thank you.
Thank you. And then I see Mr. Bondurant and I see Chelsea Bondurant. Okay, let me just get into the digital file here. Okay, I had us on today essentially for a review hearing. I know we just assigned a guardian ad litem last month, and it sounds like Mr. Bondurant might be an issue with you returning paperwork and that sort of thing. So Mr. Bondurant, let me know it sounds like you might have a request of the court.
Yeah, Your Honor, I was a little bit late to get that document out. There's a few items in there that I didn't have information on, and but it was completely on me as to why that document ended up being turned in late. It is sent by priority mail to be received by Amy, I do believe today. So, and then I also didn't realize that I would qualify for the financial declaration aspect of it to help cover the costs. So that also is being turned in today as well.
Okay. Okay. Ms. Bondurant, it sounds like we're just going to need a little more time to do, the GAL can do more investigation and give recommendations to the court. Do you have any position today?
No, Your Honor.
Okay. Ms. Turnbull?
Your Honor, I have had a chance to interview Ms. Bondurant, and I do think there's enough information that I would like to request that Mr. Bondurant do a mental health evaluation.
Okay. And because I don't have anything in front of me, can you give me a brief basis for that request?
Yeah, he has a history of, let's see, let me look at my notes here, borderline personality disorder and bipolar disorder, and has historically been on medication. And about a year ago, he stopped taking his medication. And according to Ms. Bondurant, this is when things in their relationship deteriorated and when the problem started, and has not been taking his medication for about.
Okay. And it looks like I'm just looking at the temporary order that the judge signed. Is there any visitation currently happening with Mr. Bondurant?
He's doing 2-hour supervised visits.
And is that still happening with your chosen non-professional supervisor? Is that person working out?
Yes.
Yes, Your Honor.
Okay. So Ms. Bondurant, are you requesting that he undergo a mental health evaluation?
Yes.
Okay. Mr. Bondurant, do you have a position on that? Is that something you're willing to do to move forward with review of visitation?
I mean, I got a couple issues here. I mean, it's hearsay as to make a diagnosis of any mental health issues. So I want to state on the record that that's inaccurate diagnosis of that, but I would gladly take a mental health evaluation to alleviate the court's worry on risk.
Okay. So, and I'll just state, in these types of family law hearings, the rules of evidence are relaxed, meaning things that in a civil trial would be considered hearsay. We don't have that type of exclusion here. We use GALs to do that kind of fact finding and report back to the court. So I understand your statement to the court, but I will overrule that objection. I will allow Ms. Turnbull's statement into the record. It's not there to prove the truth that you have a mental health condition, but simply as a basis for the court thinking, yeah, this is probably a good idea as we determine what's. Mr. Gilbert, can you please mute? As we determine what's in the best interest of the children. So if you're willing to do that, I do think that makes a lot of sense to move forward with determining what visitation looks like in the future. I'll do a bench order today. Ms. Turnbull, any other specifics that you would want to see in the bench order for the mental health eval?
Well, I know that I would imagine cost is going to be an issue. So I would like to see a PhD level, but I think that if we could even just get a master's level at this point to do an initial evaluation, that would be helpful. And have collateral information from Ms. Bondurant, that would be appreciated.
Okay.
Your Honor, you'd have to, I don't understand the terminology when she says collateral. Can you help me understand what she's saying by that? Or Amy, could you by chance tell me what you mean by that?
Let me ask you this. Do you have a mental health provider you currently see?
I'm in counseling, Your Honor, but as far as a psychologist, no.
Okay.
There was what was that?
Do you have health insurance that could help cover the cost of an evaluation?
No, I don't.
Okay. Ms. Turnbull, do you have any recommendations where he could go for an evaluation like that at a lower cost?
I can look into it for you.
Okay.
I mean, my request, Your Honor, would be I guess where I'm getting a little confused as to why requests are being made specifically from the guardian ad litem on a one-way evaluation. At the time, putting this over to allow both sides of the case would seem to make more sense. But I mean, if this could expedite the situation a little bit quicker, then, like I said, I don't know what the timeline would be for that because cost would be an issue.
Yep. So what I'm going to say is I'll respond to your question, and I understand proceeding through some of these family law matters is confusing. So there's a temporary order in place that a judicial officer in this county already signed. And in that temporary order, they did find you specifically, not Ms. Bondurant, but you specifically have what we call our 3A and 3B factors that may limit your ability to see the children, that in fact do limit your ability to have full visitation unsupervised. Because of that, we probably are going to put more requirements on you as we go through visitation than we would Ms. Bondurant. That does not mean though, sir, once you have your intake with Ms. Turnbull and you can tell her your concerns about the parenting plan, it doesn't mean that there won't be further requests made. It just means today, based on all the evidence I have in front of me, this first step seems very appropriate for the best interest of the children. And it doesn't,
Absolutely.
Yeah, it doesn't mean we won't be doing more or less in the future. It just means right now, this makes a lot of sense.
Okay. Absolutely.
So what I'll do is I will sign a bench order for the mental health eval and then to comply with any recommended follow-up treatment. But Mr. Bondurant, if you want to reach out to Ms. Turnbull, she's going to do some research into some lower cost evaluations that you might benefit from. Okay.
Okay, perfect.
And then do we already have another review date set?
I don't think so.
We don't. So how far out, Ms. Turnbull, would you say? Another 30 days?
I think that would be helpful. And assuming that Mr. Bondurant has, received his paperwork in the near future here.
Your Honor, can I ask you actually one other question that I don't know if it would be relevant or not? There's actually two different cases in this with my 3 youngest and my 1 older. Mm-hmm. And I know that a requirement in that case also is a mental health evaluation. Is this something that I'm going to have to do twice, or is this something that can be utilized in both cases?
Which other case? What type of case are you referring to?
It's also a family law matter, very similar to this. They're running pretty much bilaterally.
Oh, but different mother?
Yes, ma'am. Yes, Your Honor.
Okay, I did see your name on that. If I can pull the case number for that, I have no problem with those obligations being concurrent, meaning the mental health evaluation for one can be filed under both.
That would be fantastic.
Okay, let me see. Do you have his
Thank you.
other? So while she's doing that, let me give you your next hearing date. I'm going to propose Wednesday, November 29th at 9 a.m.
That works for me.
Okay, Ms. Bondurant,
Your Honor.
does that work for you?
Yeah.
Okay, do you have anything else you need from the court on this matter?
No, Your Honor.
Okay, Mr. Bondurant, does that date work for you?
Yes, Your Honor.
Okay.
Also, actually, while we're on that, from that case number, I know that Ms. Turnbull may have an issue with substance abuse at some point in her report. I actually also submitted to a hair follicle and UA that I had to pay out of pocket for. I do believe actually you required me to submit to that in that particular case. So can that be utilized also?
Yes, if you want to get those results to Ms. Turnbull, I highly recommend it.
Okay, perfect.
Okay, hold on. I'm going to get that case number. I'll get that number put into the bench order that I do. If there's nothing else, the parties are free to log off on this matter.
Thank you,
Do I
Your
have
Honor.
Jesse online?
Hello.
Hello. And then Justin Kelly. Do I have Mr. Kelly online? Okay, I'm just going to go into that digital file here. So last time we were here, Mr. Kelly was present.
Yeah, and I don't see him on there today.
Okay. So we had gone ahead, just pulling up that order. We had gone ahead at the last hearing. I did find contempt. I set today as a review date for him to begin making payments towards back child support and to take the hair follicle test within 24 hours as a way to purge his contempt. Do you know if any of that has occurred?
I haven't received any notification of that being completed. He did reach out to me this morning over text, kind of indicating that he didn't do any of that. So
Have you received any of the back child support?
no, and I haven't been contacted from child support enforcement or anything either. So
I'm just looking at your original motion. So what I will find today is, number one, he is not present and he was here when we set this date. That he, based on all the evidence I have in front of me, meaning nothing has been filed since our October 18th hearing, I will find that he has not purged the contempt. Are there additional sanctions, ma'am, that you are requesting from the court given his lack of compliance with the contempt order?
I'm not really sure like what I can't request. I guess my biggest concern is since this has gone on, I've gotten multiple messages like requesting me to not go through with court, to kind of harassment, I feel like. And I just don't want to be put in a situation where I have to go reach out to a police officer because he just takes it upon himself to like show up or do what he did last time for me to make this start this process. I don't know. He did show up at my house after I told him not to come get Jaren, and that's kind of what instigated the whole this whole proceeding.
So there are additional things you can request of the court, given the behavior in this case. I can't give you legal advice from the bench, so I would recommend perhaps that you meet with legal aid if you can't afford an attorney consultation. We do have you know when legal aid's in the courthouse?
Mondays from 12 to 2.
Mondays, so every Monday between 12 and 2, we have legal aid attorney volunteers here at the courthouse that could chat with you. So that would be my recommendation to see how you want to move forward. For now, I am going to issue just a bench order noting his failure to appear, that he has not purged his contempt, and that all visitation with the minor child is hereby ceased. He has no, you are not obligated in any way to allow visitation at this time because he has failed to comply primarily with the hair follicle testing is what I'm basing my decision on. And then if you want to bring any further requests or motions to this court for sanctions, please feel free to do so. Okay. Anything else you need from me today?
I think that's everything.
Okay. So I'm going to issue that bench order. And then, like I said, if there's further requests of this court that you have after you talk to legal aid or an attorney, please renote it. I'm not setting a review hearing for you today. Since this was just on for contempt. So again, please feel free to renote if you have further matters. Okay.
Okay. Thank you.
Okay. All right. So here's where I'm at based on my review of the file. When we were last together on September 6th, it seemed to be going very well, and we were expecting agreed orders to be presented. That hasn't happened, and now I do see that Mr. Hart has filed a motion to restrict visitation and re-review the GAL findings. I haven't yet seen a response from Ms. Hart. I can't tell if she has been served that motion or not. Ms. Hart, did you receive Mr. Hart's motion to restrict visitation?
Yes, I received that. And
It's very hard to hear you. I'm not sure if you can turn up the volume somehow.
Is that any better? I can talk louder.
Mr. Hart, I don't know if that's from your end. There's just a lot of feedback, audio.
It might be. Let me see.
Yep, that is you. So no, it's not you. Ms. Hart, is that on your end?
I don't know what it would be. I don't have anything going.
I can. Wait, hold on. I'm going to mute you just to see if it is you. Hold on. Yeah, it is you, Ms. Hart. So hold on one sec. I have you muted, Ms. Hart. I have you muted. There's a ton of audio feedback that's making it difficult for us to hear anyone else. And I can barely hear your voice. So I'm going to have you stay muted just for a minute. I think what I've heard you say is that you did receive the motion to restrict visitation. So I am going to come to you in just a minute, but because of your audio issues, I'm going to have you hold tight for just a minute. I'm going to go to Mr. Hart and to Ms. Call. So Mr. Hart, it sounds to me like we don't have agreed orders. You have some new concerns and you want those looked into. Does that sound correct?
Well, the parenting plan orders we pretty much agreed on it. There was just a couple of errors that needed to be fixed on dates where Eric lived. And that was pretty much the only thing with the parenting plan. It just some errors needed to be fixed. But other than that, we agreed on everything. But my main issue is that it was a couple weeks ago now, my son came home and while we were talking about what was going on, at one point he was like, if I'm going to be spending the night at mommy's house, how do I do that if I'm not supposed to be around Kevin? Because it said in the GAL recommendations that Kevin Johnson was not supposed to be around my son. And I just assumed that the GAL recommendations was basically the court's findings because that's what she's hired to do. And when I brought this up to Catherine, she basically just said, I talked to Heather and she said it was basically fine. And she said I could bring this back up in the court if needs be. And so I'm just needing her to follow the rules because we were getting along and everything was going so well because everybody was just following the rules and doing what they're supposed to. And then when I found this, and it's not like she disclosed that. I found it out from my son a month after he had started going over there. And so that's just my main issue is that it said in the paperwork not to be around. And it was very, very specific, and then I find out that not only is it around, but she didn't tell anybody.
Okay. Let me go to Ms. Call. Ms. Hart, I will come to you. It's difficult to hear you, but I will come to you next.
Good morning, Your Honor. So Mr. Hart is correct that I did in my recommendation state that no unmarried romantic partner should Eric have access to at this point. My only reason for that is because this is such a sensitive situation with Eric, and we know that dramatic change for Eric is very difficult given some of his diagnoses and some of the things he struggles with. My particular concern around Mr. Johnson is a very long history, specifically with Ms. Hart, with domestic violence as well as very serious substance abuse. At this point in time, I want to applaud Ms. Hart because she's really done a wonderful job on her sobriety. She's doing a wonderful job coming slowly back into Eric's life. And I can respect and appreciate the fact that Ms. Hart is excited to fully integrate Eric into her world and have him be back in her life. But we also know what we know about Eric is that going at a slow pace and doing this in a way that's healthy for him and with the support of his mental health professional and with the support of Mr. Hart and his wife, whom Eric has been living with for the majority of his life. I want to respect Mr. Hart's wishes that this timeline be respected in a very specific way. I also understand Ms. Hart has moved Mr. Johnson into her apartment, so I can understand that there's a desire here for this all to happen at once. But it is my recommendation that is not the healthiest path forward for Eric. And I have very serious concerns, given that Ms. Hart, I believe, has just hit her sober birthday, if I'm correct in that, for a year. And I respect and applaud that. But I think we need a longer history of sobriety for both of these people before Eric is put in a situation where he needs to adjust to not only these new relationship standards with Ms. Hart, but also with this other person in her life who he doesn't know and doesn't have a history with.
At the report, Ms. Hart, I'm going to come next to you. So it sounds to me like as far as the parenting plans, we're still kind of working through that, and I can give you all new dates for that. But the most immediate pressing issue appears to be your son coming to your home now that Mr. Johnson appears to be living there. So what can you tell me about that, Ms. Hart? You're going to have to unmute and speak really loud.
Okay, is that any better?
There's still background noise, a lot of it, but just go ahead. We're just going to push through.
Okay. Mr. Johnson has been sober for over 2 years. I submitted all his certificates to both the court, to Mr. Hart, and to Ms. Call. He's been clean and sober for over 2 years. He completed the drug court program in Clark County. I turned in his parenting class certificate. He completed the 52 weeks of the DV and anger management classes. So he's, I am coming up on my sober birthday here next week for 1 year, but Kevin has over 2 years. He's been at his job for almost 2 years. The reunification process between him and I, it was a process as he completed all of those classes and everything. Eric has been.
When did Mr. Johnson move in with you?
Around the beginning of last month.
The beginning of last month. So were you aware of the court's adoption of the GAL recommendation that your child not be exposed to unmarried romantic partners without consent of the other party?
I don't know about consent of the other party part, but it was after court. And Heather was aware that we were seeing Kevin, that he was coming up on weekends at that point. And I also kept her aware of his progress. So it was after our last court that he had moved back up. It was after he completed all his programs. Okay,
but also you're talking a lot about his sobriety. What I'm concerned about is his felony DV arrests. So that's a huge concern, ma'am, for the court. I'm actually just a little bewildered that you thought this was an okay path forward, saying, well, it happened after we went to court. So, I mean, we don't have permanent parenting plans in place. This is all still very much an open family law case. And I guess I'm just trying to get from you why you think this is appropriate for your child, because I don't.
I don't know what to say. Kevin and I have a 3.5-year-old daughter together, and he's completed all those classes so that our family could be unified again. And Eric is a part of this family.
So he was arrested 2 years ago, almost exactly, for felony no contact order violation, an unlawful imprisonment DV.
Mhm. And that's what he completed they entered him into the drug court program to take care of that. And that's why he went through that program and
Can you understand why Curtis Hart has concerns about his child being in this environment?
Yeah, I do understand. Mr.
Okay.
Hart, I told him even, like, I understand, like, looking at the record, I would also have those concerns.
I can't, Ms. Hart, you're gonna have to speak much louder.
I understand Mr. Hart's concerns, and that's why I tried to show him all the progress that had been made and everything that had been completed on Mr. Johnson's end.
Ms. Call, I am troubled by this. This is very different than what was presented to the court by Ms. Hart when we thought things were all moving forward. I understand Mr. Hart's concerns. I frankly am very concerned. I also don't want to, normally what I would do in this situation is essentially terminate visitation until we work this out. I don't want to do that. I think this child has been yo-yoed enough, but I don't know what else to do with these concerns with a very recent history of domestic violence. Significant. We're not talking misdemeanor domestic violence. We're talking felony domestic violence.
Your Honor, I share those concerns. And the DV case was actually against Ms. Hart. She was the person involved with this issue. And she and her daughter essentially fled her relationship with Mr. Johnson. And when I first visited with Ms. Hart, and she did share with me she was having digital visitation with Mr. Johnson because he is her daughter's father. And I had asked her specifically, and I wrote about this in the report, if she was still engaging with Mr. Hart. She said she was. And that's what led me to make the recommendation that Eric not have to have a relationship with unmarried romantic partners, specifically because of the concerns that you're bringing up, Your Honor. I have very serious concerns about this as well. At this point in time, I think it would be very hard on Eric to go back to not being allowed to see his mother. And I have concerns that Eric would not understand why that's happening. But I do think either a once a week visitation or even a supervised visitation may be appropriate until Mr. Hart feels that there is enough trust established that Eric can safely be in this relationship. It is true that he has a younger sister who I think he should have access to. They have a bonded relationship that I think is valuable. And I do believe that a bonded relationship with his mother going forward is appropriate. However, I think that at this point in time, we need to see that that's going to be a healthy and an appropriate relationship in a way that's safe for Eric.
I agree. Mr. Hart, what is your hope here? What are you feeling comfortable with?
Well, I feel like I agree with the whole like unmarried partners thing, at least for like, like I would imagine like 6 months, because he doesn't really know his mom yet. Like he's just getting to know her. And it's for those specific reasons, like everything you were talking about, like they had to crawl out of a trailer window with her baby, according to the paperwork.
Yeah, I understand.
And that's like, I just don't want my son to ever have to be put in any type of situation where a stepchild annoys a stepfather. And so like, I also don't want him to not be able to see his mom because he's doing very well. Everything's going very well. I was under the impression, like I've been told by Alice, that Kevin has a mom. Like he can just go to his mom's house and not be there. As far as I'm concerned, like he could still totally go and hang out there as long as Kevin's not around. Like I thought that he wasn't. And if he's not there, because Eric's in this school program where he's going to like in a leadership club, and so he needs to get like a different ride besides the bus in the morning. And so he was going to be going over there on Wednesdays. We switched it to Tuesdays so that he could spend the night and then go to school from her house because she's just right down the road from his school. And she came and she picked him up this morning and drove him over there, which is great. But like, I'm like, if Kevin's just not there, like I'm fine. I just need the courts to tell me that he's fine. If he's fine, if he's not fine, I don't really know what to do.
Ms. Hart, my inclination is to issue a bench order that allows you the continued visitation as is, but the stipulation is that Mr. Johnson cannot be at the home when your child is there. Can you make that work?
I'm sure between me and Mr. Hart, we can figure something out. That's what we've been doing. And Mr. Johnson works full time, so a lot of times he's at work anyway.
Okay.
So I don't know if we can figure something out until maybe are able to get this reviewed again once. I don't know if Heather's reappointed and she can look into, I don't know, verifying his, completion of classes and everything that was required for him to come back with me and my daughter.
Yep, I think that is a good idea. What I'm going to do now, we'll set a review date on this to allow Mr. Hart. I don't, Ms. Paul, are you at your cap with this case? I'm not sure where you're at.
I am. I'm beyond my cap. It's a county pay case. I actually went beyond the cap on this case, but if Your Honor feels it appropriate for me to remain involved, I'm happy to do so.
Okay. I am, and I will approve additional hours and monies for this case. I think it's important in this unique scenario, and you can send that any type of request for fees directly to me, because I know why I'm making this ruling and why I'm requesting additional hours. It is for the safety of the child. I'll know specifically with felony DV cases, typically there's a 5-year probation period where a court is monitoring. So I really am just not comfortable right now with anything other than what I'm going to order, which is at least until our next review, that Mr. Johnson not be present when the child is visiting Ms. Hart. How far out do you all want to review this?
Well, Your Honor, given that we're coming into the holiday season, and I will confess my caseload is quite stacked at the moment. If we could get into the new year, I know that's a long wait. I know it's a ways out, but I want to be sure that I can actually give this case my attention.
Yeah.
If it's possible to get into January, that would be very helpful for me. I assume at this point I'm going to need to do some interviews with Mr. Johnson and spend some time with Eric. And so I just want to make sure that I can do the appropriate investigation.
Yeah, I'm thinking January, let's get us a little bit past the new year, January 10th. Would that work for the parties? That'll be a Wednesday. Well, are they keeping this docket Wednesday at 9 a.m. in 2024?
Well, and just so you know, Your Honor, I do have a review hearing that morning in Clark County.
Okay, so we'll pick a different date.
I'm available on the 17th if that works for everybody else.
When will it be?
Wednesday's 9 is supposed to be.
Oh, it is still going to be. Okay. For now. Now, if we change, 2024 brings in docket changes, we'll certainly advise the parties. But for now, let's set this review for January 17, 2024. I wrote 2023. 2024 at 9 a.m. That'll still be the Wednesday Zoom docket. And then I know we had the orders, the agreed orders. I would probably say, that the court is going to want to see this further investigation before we do any sort of final orders. So I would hold tight on those for now.
Okay. And would Your Honor appreciate an amended report, or would you just like a verbal review?
I'm fine either way. Probably I'll leave that to your discretion, depending on how in depth, the interviews go and the information you need to get to the court, but I'm fine either way.
Okay. All right.
Okay. We'll see you all back on January 17th. Anything else the parties need from me?
I don't think so.
Okay. All right. We'll see you back on January 17th. You're free to log out.
Thank you, Your Honor.
I'm here, Your Honor.
Yes.
Great. I see everyone present. I have this on for a review of compliance with the evaluation. Mr. Gilbert, I don't see anything in my file. So let me start with Mr. Lawrence and then I'll come to the parties.
Your Honor, I checked with Odyssey yesterday and I again found nothing there. I have received nothing through email for Mr. Gilbert. And so my assumption is that he has not complied yet.
Okay.
I have a date set.
Oh, great. What is that date?
November 28th. It's a Tuesday.
Okay. And
I didn't know I was supposed to apply with everything else. It's with the Dr. Stevens or whatever for the psychiatric evaluation.
Yep, the psychological evaluation. Okay. You said that's November 28th?
Yep.
Okay.
It's a Tuesday.
Great. So
it'll
Oh, just a second, sir. Hold on. I'll come to you with any further input or questions. Let me just do the basics we need to get done. If that's going to be on November 28th, it will likely take some time to get the report to the parties and have a chance to review it. So I would recommend we come back I know this is during the holidays, so I don't know people's availability. We could do December 20th or 27th, or we could bump it into January. Mr. Lawrence, what's your schedule like?
My schedule is free, Your Honor. However, my experience in working with Dr. Mahard is that his initial appointment is going to be like a clinical interview. There may be a separate date for him to do testing. And then there's going to be collateral interviews with Dr. Mahard. And so my suggestion is we wait into January in order to get all this stuff together.
Okay. Mr. Gilbert, did you want to say something?
Yes. Is there any way I could see my kid unsupervised? I mean, I do not understand this. I've got nothing in my past, nothing in my history, nothing at all that says I can't be around my own son. I mean, the stress this has caused and everything. I'm not working right now. This has caused ungodly stress on my life, my work, everything. I mean, at first I was not telling anybody about this because being branded an unfit father that can't be around his kid, but it's just gotten to the point it's unbearable.
Okay. I will comment on that after I hear from Ms. Gilbert. Go ahead, Ms. Gilbert. What's your input on, I guess what Mr. Gilbert just said, but more importantly, if our follow-up court date in January works for you? I'm looking at probably January 17.
Yes, January totally works for me. I do want to say, I just want to make sure that he is getting the right test, like the drug test. He did not do the right thing. So I just don't want to come back in January and find out that he did not do the correct evaluation. So anyways, but yeah, as far as unsupervised visitation, I'm still at a hard no if possible. He has done nothing to comply with the court, basically. So
yeah. Here's going to be my ruling. I am going to set our review date on the psychological evaluation completion and report to January 17, 2024 at 9 a.m. I, at this time, am declining to revisit or revise visitation. I think what the court has put into place is appropriate under the circumstances and facts in front of me. I disagree, Mr. Gilbert, that there's nothing in the file to support the type of visitation we have put into place. So I am leaving it as is until we get the results of the psychological evaluation and further input. I think you'll remember from my August bench order that I did also have concerns about the living environment with which the child had been exposed to in your home. So I'm going to leave visitation as is through January 17th review date. Anything else the parties need from me?
I would like to know why the court's recommending this.
So I've already made my record in all of my bench orders. We've talked about this numerous times. Every time you've been on, it's been like pulling teeth to get you to do the evaluations the court has asked of you. So I've issued my ruling. Visitation stands as is through January 17th, our next review date. I'm very glad to hear that you have the evaluation set up for November 28th. And I wish you the best of luck through that process. And we'll talk again January 17th.
Thank you, Your Honor.
Thank you. You're free to log out. So there's several things noted on my docket for today. Two of those are show cause motions from Mr. James, I believe, regarding the fact that he alleges Ms. O'Brien has moved without going through the formal relocation process with this court. There was also a restraining order request. I don't see that we've had a hearing on Ms. O'Brien's relocation request. Let me start with Mr. James, since he filed the show cause contempt motions. What is your position today, sir?
Back in late July, Miss O'Brien told me that she was going to move to Oregon because she didn't have any other options. I expressed that I did not want my daughter moving to Oregon, and she went ahead and did it anyways. So that is why I did the contempt paperwork. And then in September, she told me that right now where she's living, it's not physically or mentally healthy for our daughter, and asked me to take her full time. She did ask for a weekend with her, and I gave that to her because I'm not trying to keep money from her mom. And then during that weekend, she told me that she was not going to give me Ryan back after our daughter's been living with me consecutively for just about a month. I got her on a schedule. You know, she has a regular bath, dinner time. She gets up, she goes to school in the morning.
Well, yeah, so hold on. I think we're getting a little far off track. So I need to be real specific on what we're doing here today. So a couple things. Ms. Barnes, have you moved to Oregon with the child?
I have since relocated back to Washington.
You are back in, where in Washington are you?
In Longview.
You are in Longview? Okay.
Yes.
And then where is the child? Are you all still adhering to the parenting plan in place, or has that changed?
No, she's still with Brandon.
Okay. Mr. James, is that all correct?
Yes, Your Honor, she is with me, but as of just the other day, I was informed that Miss O'Brien has moved her biological mom in with her and her boyfriend in her studio apartment in St. Helens. From
That
Miss
is
O'Brien.
incorrect.
Hold on just a second, ma'am. I'll come to you in a second.
That information came from Miss O'Brien's family.
Okay. So Miss O'Brien, you're asserting to the court that you are back in Longview, Washington?
Yes.
Okay. I don't see that you have filed any response to the show cause motion. I do see that you were just served with the amended show cause contempt motion just on October 18th last week. Do you believe that you have documents that you could prove to the court that you reside in Longview, Washington?
At the moment, no, I do not, but I can get the documents.
Okay. What I'm going to do just on the show cause contempt regarding the move, I'm going to allow, how much time do you think you need to get that evidence? If we set you out 2 weeks, could you have that?
I can do my best to get that.
Okay. So, sir, on your two show cause contempt motions, and mostly it's an original and then an amended, I'm going to set this to November 8 at 9 a.m. And ma'am, what you'll need to do is just serve any responsive documents on the court and Mr. James that shows where you currently reside.
Okay.
Okay. So, and Mr. James, I'm going to come to your restraining order request in just a minute. But first, Ms. O'Brien, you had filed a notice of intent to relocate. Are you intending to strike that?
Yes.
Okay. So you're no longer asking the court to rule on your ability to move?
Yes.
Okay. So I will note that you are striking your notice of intent to move with children that was filed with our court October 11th, 2023. So we'll take that off the table for discussion at our next hearing. And then Mr. James, let's move to the last issue I have in front of me today, which is the temporary restraining order you requested.
Yes, Your Honor.
And this obviously would preclude any sort of visitation with Ms. O'Brien. Are you asking for that restraining order to continue?
Yes, Your Honor.
And can you give the court the basis for requesting that it continue?
I'm not sure if you have it in front of you.
I do. I have it in front of me. I'm just asking for your oral testimony on why you're requesting this.
Because I have been informed that Miss O'Brien's significant other has abused drugs and has done illegal substances in their house.
Ms. O'Brien, do you want to respond to the request for a restraining order?
I do want to say that I no longer have a significant other. Okay. With moving back to Longview, we ended our relationship.
Okay, so here's what I'm going to do. I will note that a temporary ex parte restraining order just through today's hearing was signed by Judge Evans on October 13th. I am going to reissue it just on a temporary basis through the date of our next hearing, which I set for November 8 at 9 a.m. The reason I'm doing this is that I think there is a declaration filed that does support the restraining order that causes me some concern about the safety of the child with Ms. O'Brien currently, but I think more appropriately because there were significant concerns about Ms. O'Brien failing to comply with court orders and moving the child out of state without going through the proper procedures. I think the restraining order is also appropriate. Through the date of our hearing, I will revisit the restraining order issue on November 8th. And Ms. O'Brien, what I would ask from you is to submit any documentation regarding sobriety and safety in your home. I would also ask that you again provide the indication that you are residing back in Cowlitz County. Okay? Okay. Any questions for me from the parties? Otherwise, I have signed the restraining order. It does not need to be served on you, Ms. O'Brien, like the last one, because you are here to hear about it. But I would recommend that you come get a copy of it because it does preclude all contact with Mr. James and your minor child with the initials RWJ. You're not to go within 200 feet of the protected persons. You're not to own, possess, or control firearms. I'm not issuing an order to surrender because of a case called State v. Flannery, but I am stating on the record that you're not to own, possess, or control firearms. Any questions?
Just where would I be going to, like, get the test done? I don't.
Any sort of UA clinics where you can get a UA, is that what you're asking?
Yeah.
Yeah, I can't give you any specifics, but there are agencies all throughout Cowlitz County that will do UA testing for you.
Okay.
Okay, and then I'm going to reserve on the contempt motion until our next hearing on November 8th. Okay?
Okay.
All right, Mr. James, anything else that you need from the court?
No, Your Honor.
Okay, thank you both. You're free to log out.
Thank you, Your
Good
Honor.
morning. Thank you.
Morning.
So what I show is we're simply here on a review, kind of where we're at with regard to the remainder of the dissolution proceed payout.
Are you asking me?
Yeah, it looks like Mr. Westling, that there was retirement account issues that were still outstanding. It looks like Ms. Westling had been given some paperwork to fill out.
Yes. As far as paperwork, everything's been submitted. She has an account where the money is supposed to go. We're just waiting for the money to show up.
Now?
I can, go ahead.
Okay. He told me yesterday he has some papers I have to sign for that retirement account.
Okay, and you haven't done that part yet?
He just told me about it yesterday. So.
Oh, okay. Do you want to go ahead and just set this over for review in about 30 days?
Yeah, that sounds good to me. It should be through by then.
Okay, let's set this to November. Do you want the day before Thanksgiving or do you want the week after Thanksgiving?
Ask him.
The week before will be fine.
Okay, so let's do it's the week of, so it'd be November 22nd at 9 a.m.
Okay.
All right, that's okay with me.
Okay.
November 22nd?
Yep.
Okay.
All right, that'll be the new review date and we'll see where you all are at that time.
Okay, thanks.
All right, thank you both.
You have a good day, sweetie.
You too, thank you.
Yes, I'm here.
Bye-bye.
And then Gregory
All
Smith,
right.
number 14.
Reeves. Oops, sorry.
Reeves, sorry. My docket, my printed docket's all over the place today. Okay, Gregory Reeves, thank you. Cassandra Davenport. I had this on for temporary parenting plan review. Where are the parties at?
Okay, so I feel like a lot of stuff came up. I almost backed out, and I thought, the plan was that eventually we were going to get to a comfortable point where it would just be 50-50. We both agreed on no child support. So I had submitted those. I had concerns about drinking and driving with my daughter in the car. And I just requested that if I have any concerns in the future, that I'm able to request a UA. But other than that, I'm okay with the 50-50. I did get served with her paperwork, and I'm not okay with that because I don't feel that that is 50-50. I like my time with my daughter, and like my schedule with my daughter is, I get off work, I go, through the whole routine. We hang out, feed her, eat dinner, I bathe her, I put her down for bed. I mean, I'm just doing this with my mom. Occasionally she sees her auntie, but I feel like we really have a good thing going on, and I don't want to have to go to her mom every night and drop her off at her mom's or have her mom pick her up. I kind of prefer to not have that much contact with her mom, and I just really feel good about what I have going on in my 50% of the time and don't want to give up any more than that.
Yeah, I did just see, so when I actually reviewed this yesterday, I did not have your proposed parenting plan scanned into the file yet, Ms. Davenport. So I haven't had a chance to look at it. It looks like it was, you filed it on Monday. So it's available to me online today, but it wasn't yesterday when I reviewed this case in preparation. So I haven't been able to see where you all disagree specifically, but it sounds like we're not quite at agreed order place. So let me ask the two of you this. You've never had a guardian ad litem appointed. That is, you've probably seen them online where they interview both of you, other people involved in the child's life, and make recommendations to the court. Is that something that you would be interested in having involved in your case?
I would rather not, if possible. So with me, I'm for 50-50 because I feel like that's the best thing for our child, to have equal time with her dad and me. It's very healthy for her, and she's safe with both of us. My only concern is I was asking for first right of refusal, because Adeline,
first right of refusal in this, what does it mean to you?
From my understanding, when it comes to custody, would be that he would call me if he needs childcare first. So instead of Adeline staying at her grandma's during Greg's days, he would still get his time with her, and then she would just be with me during the night instead of staying those nights at his mother's. And I want her to have a healthy relationship with his mom, which is her grandma. And I see how this is affecting my daughter and her relationship with his mother. She's really upset. She doesn't understand why, if she can't be with daddy, why she can't be with me. And it's really affecting her. And I feel she's 4 years old, and I feel like she needs to be with her dad and me. And that's where she wants to be. So I don't understand.
So typically I rule that in these types of situations, absent extenuating circumstances, that the parent whose residential time it is gets to decide who is watching the child if they have to work or do other things. So I don't typically grant what you were calling first right of refusal is not something I typically grant. Here's my recommendation. You all appear to be close, but again, because your proposed plan was just filed, I haven't had a chance to sit down and fully compare them. I would recommend that we transfer this to mediation, have you all meet with a mediator to go through your differences and see if you can bring back an agreed plan to me rather than doing a GAL. Would you?
How much does mediation cost?
Let me pull it up. They just told me it's not much. Well, it's way cheaper than a GAL. I do know that. The charge per mediation, and it's done here locally, is $310. And I typically have the parties just split that 50-50. Would that be something that you all would be interested in?
If we have to, then yes. My other concern was basically the childcare that she is put with in Greg's time with our daughter. When she goes to her aunt's, she is exposed to so many foul things. She comes back with regression in behavior. She's very sexually curious. It's not healthy for her. They do drugs right in front of her.
And again, so we don't have, if there's allegations of drug usage, then I'm going to request a GAL. That's not something that I have documentation of. So if you're requesting that visitation be limited because of significant safety concerns to the child, then that is something we would need a GAL for.
That's not what I'm requesting. I don't understand why she can't be with me
instead of going overnight to someone else's house when I could provide her stability. It's
not your parenting time. That's why.
Can I say something?
Yes, please do.
Yes, I wanted to ask your suggestion because I know that she has a thing against her sister. I have addressed all these problems. I have actually gotten mad at her sister and asked this stuff, and her sister gets very defensive, says she doesn't do that, that she's willing to take a drug test, hair follicle test. I don't know what to do in this situation because the last judge that we spoke to said, you know, Adeline was in her care for so long not to rip her away from her auntie. I have limited that she maybe once a week, if that, like sometimes she goes 3 weeks without even seeing her auntie. So it's like, mainly it's just me and my mom. And that is, you know, the best, you know, that's how I like it. But I do, you know, she misses her auntie. I sometimes, you know, let her go stay the night there. You know, I've addressed all these problems and, you know, I haven't taken it lightly. And she, within responses, says anytime, hair follicle test, you know, have somebody stop by, whatever. So I wonder if sometimes it's just something that's, you know, because they're sisters and they don't like each other. But I don't know what to do in this situation. Yeah, the easiest thing would just be like, yeah, she can't go there. But, you know, like she's going to miss her auntie and, you know, she was a big part of her life.
All right. So I think I've heard enough. I've looked at the history of your case. I am a little confused why we've never had a GAL appointed. I see that you guys, that this matter was in guardianship proceedings for a period of time. I, on the court's own motion, am going to appoint a GAL because there are a lot of allegations going back and forth. I don't believe this is something that you all are close in agreement on, even if it appears that way on paper. I think there's significant safety concerns that are being raised for the child. What is the current age of your child?
4.
Okay. Who are the next 3 GALs? I'm going to read off 3 names and then I'm going to see if you guys want to strike any of them, if you know them or had an experience with them. Ann Height, Twyla Corey, and Heather Cull. Do you want to strike any of those? Oh, I'm hearing no objection, so I'm going to sign Ann Height. I'm going to set some review dates in a minute, but first let's talk about payment. I'm going to ask you all a little bit about your income to determine if the county pays for this, you all pay for this, and at what portion. So Ms. Davenport, first, what is your monthly income?
Right now I'm currently temporarily on TANF. So I think it's 530.
Okay, so you're not currently working?
No, I'm taking classes to become a CNA.
And how much longer do you have in that program?
Probably about a month, maybe.
Okay. And then, sir, what is your monthly income?
I think roughly about $3,000.
Okay. And then is that before or after taxes? Is that your take-home pay?
Yeah, I think that'd be about my take-home pay.
How many people do you support on that?
3.
3 dependents?
Yeah.
Okay. So what I'm going to do is indicate that this will
have 3 kids.
Well, no, 2 dependents and 2 dependents.
But yeah, okay. So this is going to be county pay. What I'm going to do is indicate that 50% of it will be reimbursed by the respondent. And then 50% will be paid at county, or excuse me, at public expense. So that would mean the maximum the GAL can charge, just going to get out my calculator here, in a county pay case is $1,485. So then the max that the respondent would be reimbursing at conclusion would be $742.50. The GAL is going to be, I'm also going to reserve on petitioner's reimbursement. We'll re-review if you do become gainfully employed before this is concluded. And then the GAL is going to be tasked with interviewing both of you about the concerns you have about either party regarding any issues of substance abuse, mental health, anything like that. We're going to do a 30-day review. So let's set that to, are the two of you free the day before Thanksgiving, November 22nd?
I think that should be fine.
Okay, then the interim report will do. Let's do that the end of, well, let's bump that into January. Let's say January 7, 2023, 9 a.m. And then February 14, hopefully for the final report. So when Ms. Height reaches out to the two of you, please make sure you get back in contact with her.
Okay.
Any questions for me in the meantime?
So the guardian ad litem will be getting hold of us first. We don't have to reach out to her first, or?
Correct. She'll be given your contact information and she'll reach out as soon as she has the document and the order in her file.
Okay, and what's her name again?
Ann Height.
Okay.
Okay. All right. Thank you both. We'll see you back November 22nd.
Yes, ma'am.
I'm showing, the most recent thing I show is that you all are asked to come back to finish mediation.
Yes, ma'am.
Is that correct?
Yes.
And do I have the petitioner online too? I don't see him.
No, he is not here because me and the sheriffs were unable to serve him.
So he hasn't been served notice of today's hearing?
Yes, ma'am.
Okay. Ms. Looney, is there anything that the state needed on today's hearing? Otherwise, my inclination is to strike since he hasn't been served.
Your Honor, we're going to ask to remind the parties to serve us with any documents, since it looks like they're going back to mediation about an agreement so that we can draft a proposed child support order.
Okay.
And I do have a phone number if Ms. Thomas needs that.
Ms. Thomas, do you have something to write with so you can get the state's phone number?
What am I doing with the state?
This is for child support orders. You need to serve them with documents that you're proposing to the court.
Is Kenneth going to be serving them with any documents because he's failed to properly serve me?
We have nothing from him, but if the case is moving forward, we need to have documents from you if you file anything. So you can call our office to get instructions on how to do that.
Okay.
Okay, I'm just looking here to see. It does not. So let me just ask you, Ms. Thomas, he had proposed the order transferring the case to mediation with a 50-50 cost split. I do see that mediation looks like it started. Is that right?
Yes, it actually looks really promising. Our first session went really well.
Okay.
Our next one is Monday, and I'm hoping we could get a lot done just because it's gone so well the first round.
Okay, so what date did you have your first mediation?
I believe it was 2 weeks ago, 2 weeks from Monday. So it was, I think it was the 9th.
Okay, so you already have your second mediation scheduled?
Yes, for the 30th Monday.
Okay, so I don't need to sign anything then. So what I'll have you all do, I'm simply going to strike today's hearing since there wasn't service, but go ahead and go to that mediation. And then depending on how that concludes, go ahead and one of you can renote this matter back on the docket. Make sure you serve the state through Ms. Looney's office, okay?
Okay.
All right, thank you. It's on for a review hearing. In the interest of time, I think I'll start with Mr. Lawrence and see where we need to go. I think I have one case besides yours to do, and I'm going to try and get everyone done in 7 minutes. So the buzzer is started.
Your Honor, my final report is due at the end of November. As the court is aware, Tanya and her husband moved to Texas. and the court allowed her to have visits as long as they occurred in the state of Washington. And she did exercise one of those visits just recently. And she is asking that the child be allowed to go to Texas for a visit as well. Mr. Perkins had some concerns about Ms. Johnson's current husband. His name is Trigg Johnson. He is a truck driver, and I did a nationwide background check on him. And what I discovered was a phishing violation in 2012 and a theft in 1997. Other than that, he has several traffic tickets which are related to his profession. But I found nothing of any concern that would raise a red flag as to whether or not the child can go and visit its mother in Texas.
Mr. Perkins, so obviously we will, come back once we have the full GAL report, but it sounds like in the interim, Ms. Skelton is asking for approval for the child to visit her in Texas. What is your position?
I mean, my position has been and will continue to be at this point that he's too young to be traveling back and forth on an airplane, even though his mother will be with him. And her request for the frequency of the visits is also concerning to me.
What is the frequency requested?
According to our last conversation when she came up here to visit him, she would like a month on, month off visitations, which to me is just for his psychological and emotional well-being, not a good idea.
Ms. Johnson, what is your request of the court?
That was just a suggestion that I had, being that I went a month without seeing him face to face, and Clayton over video calls had gone from being very excited to see me to being not very interactive with me over the video calls. So I was just wanting to have a longer video or longer face-to-face visits with my son, if that was at all possible, instead of going longer times without seeing him. That's why I was suggesting a month with him. And because it does cost quite a bit of money to go down there to get him or to see him, it would make it more cost worthy for myself to have him here for a little bit longer of a time period.
Okay, so, and just so I can understand the facts fully, he's 2 years old currently?
He is, yes.
Okay. And then when did you move to Texas?
About a month ago.
Okay, 1 month ago. And then up until the move to Texas, what did visitation look like?
It was about every other month or every other weekend. Sorry, Your Honor.
You had him every other weekend?
Yeah, Mr. Perkins and I were on an agreement about every other weekend.
Okay. So I think, I do think 1 month on and off, given the history with visitation, doesn't seem to make a lot of sense. That's not what the child is used to. I think that would be very disruptive to a 2-year-old. I am willing, it sounds like, just based on, temporarily putting a visitation order into place, I am willing to allow Ms. Johnson, you to fly here to get child and child fly back with you. Obviously, I'm not going to allow a 2-year-old to fly unaccompanied.
No, of course.
But I will allow it, but I'm not inclined to do 1 month on, 1 month off. I do understand the cost hindrance, though. My initial thought, and I'm open to input from Mr. Lawrence and the parties, I think given even before the move that he was only with you on weekends at most, but taking into account the cost and time encumbrance, I would be inclined to say, 1 week a month at most right now until we have the full GAL report. Mr. Perkins, is that something that you're comfortable with?
Well, I mean, the GAO report's due at the end of November, so I mean, I don't see why any more visitations can't wait until that comes out.
Okay, well, so my question isn't that. My question is if you'd be comfortable to 1 week a month until we make a final decision.
Yes, I can agree to that. I am reluctantly agreeing to it, but
And you
I
don't,
mean,
I'm asking for your honest input. I'm just throwing out ideas here, so I'm getting your input.
okay.
Go to the other parties. I'm not asking you to agree or disagree with anything, just whether you're comfortable with 1 week.
I'm not comfortable with it, no.
Okay.
I'm not comfortable with having my son that far away for that period of time. At this point, I feel that her main reasoning is not for his best interest. It's more for her best interest. And it's just not a situation that I'm comfortable with.
I understand you have been the primary parent at this point, so I take your input. Mr. Lawrence, what is your input for the court on this, just pending a final report?
Your Honor, we actually addressed this very issue when we set up parenting plans for summer visitation. Historically, the court will order 2 weeks of uninterrupted time. However, when the child is little like this, going beyond a week seems like a lifetime to this child and may start creating bonding issues with the other parent. And so at this point, I believe that if Ms. Johnson was allowed to have up to 1 week, that would be terrific. And then if she wants to come back up and visit with him within the confines of by the end of November, she would have 2 more visits with him, and that would aid me in seeing how the bonding is going as well.
Okay, thank you for that input. Ms. Johnson?
Yes, Your Honor.
Go ahead with your input just on this temporary proposal until we have a full investigation and report.
I'll do what I need to do. I mean, going down there for that many times is going to be very costly for me, but I mean, to see my son, I'll do what I need to do.
Okay.
I would love to get him here to visit me here, but I'll do what I need to do.
So what I am going to do, just pending our next review, which do we already have that set for the 22nd? Or sorry, the 29th? Looks like we do.
That's my understanding, yes.
We do have a review hearing November 29th. So just between now and then, I'm going to do a temporary bench order that does allow you, Ms. Johnson, 1 week to fly your child accompanied to be with you in Texas. That will be up to 1 week a month. I know that's probably not feasible every month, but that is going to be my order. I take into account what the child is accustomed to, and I think I'm even pushing the envelope a bit with what the child is accustomed to with weekends with you. I also take into account that it was your choice to move. So, that is something that the court has to look at. The visitation in Washington is still an option to you. So in between the visits in Texas, if you want to come up here and engage in the visitation that's already been put in place where you are present in Washington without taking the child out of state, I will still leave that in place. And then we will re-review this matter on November 29th. I will put into my order that the week with you in Texas does need to be coordinated with Mr. Perkins. So it does need to work for his schedule. I do anticipate that there could be issues that come up with the two of you working on what week that could be or should be. But I'm going to encourage you, at least at this point, to work together on that. But I am going to put in the bench order that Mr. Perkins needs to agree to the week that you've picked. So it can't be a scenario where you just tell him what your flight details are. It needs to be something that he can also make work as the primary parent currently.
Of course, Your Honor.
Okay. And then we'll be,
Your Honor, may I add something?
please do.
What, with this order with him going to Texas, if she decides to keep him, what's my, what options do I have as far as recourse of trying to get him back?
Well, you're going to have a visitation order that only allows him to be 1 week in Texas. There would be criminal implications if a non-custodial parent does not return a child after visitation. So probably, you would have the ability to contact law enforcement at that point.
Okay, thank you.
Yeah, you would. Yep. Yeah, you will have an order from the court limiting the visitation to 1 week out of state. Okay, anything else we need? Otherwise, I'll see the parties back on November 29th.
Nothing for me, Your Honor.
Okay, thank you all. I had this on for review. This is a case where filings have been made in Pacific County and Cowlitz County, so we really haven't been able to move forward. I have nothing new from Pacific County. They haven't been in contact with us.
So, Your Honor, speaking of that today, I'm actually glad you brought that up first, is because I spoke with the lady. I had scheduled meeting. I had got my first set of papers in. I am actually waiting to schedule.
Are you talking about in Pacific
County?
Okay.
I'm just waiting to get back with her to meet with her again to get the rest of my papers that I would need.
Okay. When do you have do you have a court date in Pacific County?
Not yet, Your Honor, because I'm with the papers that I need. They have to be positioned in Pacific County.
Okay. Ms. Linden, do you have any updates about Pacific County's role in all of this?
I have not received anything except for the original court date that everything started at.
And what date was that?
Give me a moment to go through my paperwork.
Okay, no problem.
If you may, Your Honor, I can give you the exact date, no problem. It's October 18th is when I filed. The first court date was November 18th, I believe.
Of this year or last year?
Of last year.
Yeah. So that's my concern here, is that the Pacific County case was filed about 8 to 9 months before anyone filed in our court. So it is still my belief that Pacific County is the proper jurisdiction for this.
Okay.
What I've talked to you both about is that I typically have been able to schedule conferences with the other jurisdiction, so that jurisdiction and I decide, is it Cowlitz County, is it Pacific County, who's taking this case? Right now we have a situation where we've had the same type of proceeding filed in both county. Typically the first in time would take precedent, but I have not been able to get a response from Pacific County to confirm that they are taking jurisdiction and hearing this matter. All I can do today, unfortunately, and I'm sure this is frustrating to the parties in our county, all I can do is simply set a new review date to see if we can get Pacific County on board with making that joint decision with my court, which is what our judicial staff have been working on since the first time I met with you all.
Exactly, Your Honor. And I'm in the same position. I just want to be able to get this to move forward to where it's at. I'm tired of being in this position where Miss Linden's not, helping move the process forward.
Okay, so what I'm going to do, folks, and Ms. Linden, I'll give you a chance to speak here in just a second. I want to give you a new court date. I'm going to set it out a little further, just knowing that we have Thanksgiving coming up and that there's things in play with Pacific County. Let's set you for December 13 at 9 a.m. to review the status of jurisdiction between Pacific County and Cowlitz County, okay?
That works. And Your Honor, in that process, when I do meet with this lady in Pacific County courts, if I'm able to file those papers, am I able to file in Pacific County?
I'm not going to give you advice about that. I'm just going to say, do what y'all need to do in Pacific County. I'm going to continue to reach out to them about who's taking jurisdiction and then come back to my court on December 13th at 9 a.m.
Okay, sounds good, Your Honor.
Ms. Linden.
Your Honor, I found the paper. It says June 15th that it was done, but at the very first court date with Pacific County, it got scratched because he did not have his full paperwork. And that was the only time that I was served by him.
Okay. Yeah, June 15 of 2022.
That's incorrect, Your Honor.
Of this year.
Of 2023. Okay. Well, again, either way, whether it was this year or October of 2022, that's still first in time from filing in Cowlitz County, which was July 3rd of 2023. So we still need to make that jurisdictional decision. I'll see you both back on December 13th. I appreciate your patience waiting through this long docket.
Thank you, Your Honor, and I appreciate your time.
Yep. Thank you both. You're free to log out. Thank you. Okay. Did I miss anyone? Okay.